Now that we have disproved what Chris and Peter have said about IP addresses and tracking, shall we move on to the legal threats that they are making about online creators? Firstly, let's define the allegations they are making. They would fall loosely into two possible civil actions. To note, the civil is particularly important in this statement. The reason for this is that unless an actual crime is being committed, then there is no jurisdiction for law enforcement to get involved. An example regarding this would be committing the act of trespass. This is in itself a civil matter and therefore not a matter for law enforcement, unless the trespass becomes aggravated, in which case it becomes a criminal matter, and then they have the jurisdiction to get involved. So going back to our two related civil actions or lawsuits, what are they? One, libel, a written or broadcast defamatory statement. Can appear in newspapers, magazines, blogs, social media, or other publications. The law of libel, you are required to prove that you have suffered serious harm to your reputation. Two, slander, an oral defamatory statement. Can be made about someone's character or professional standing. The law of slander says that, in most cases, you have to prove that you have suffered actual financial loss as a result of the slander, as well as serious harm to your reputation. So, as we see above, both these actions require the presence of a defamatory statement. So let's see what the legal definition of defamation is. What is a defamatory statement? A statement is considered defamatory if it is presented as a fact, but is actually untrue, and if it damages the reputation of the person or entity being targeted. The key point here is presented as fact. This is especially important for ensuring the threshold of defamation is met. Due to free speech and how society works, it is important to determine the difference between someone presenting facts and sharing an honest opinion. Also to note, something being an honest opinion is actually a defense to defamation action, as unless the statement can be shown as made as fact, John stole that purse, versus, well, it was unusual. John was the only person in the room with the bag, so he could have stole the purse, would be regarded as an honest opinion. The other factor to bear in mind is that the statement of fact has to be false. Using our example above, John stole the purse, whereas it was Dave who stole the purse. An interesting factor with defamation cases is the burden of proof. In any legal matter, criminal or not, it's up to either the plaintiff or the defendant to prove beyond reasonable doubt that the matter is true. Most people are familiar with the common principle of innocent until proven guilty. With regards to criminal proceedings, this means the burden of proof rests on the plaintiffs, normally the country's prosecutors, to prove that the defendant is guilty. In defamation cases in the United States of America, the burden of proof in a defamation case usually lies with the plaintiff, person bringing about the action for defamation, to prove that the statement is false. However, conversely, in the UK, this is reversed, and the burden of proof lies with the defendant to prove the statement they presented as fact is true. Regardless of this, in either civil or criminal cases, proving the case relies on the usual legal protocol of examining evidence and calling witnesses for examination and cross-examination under oath. Even if it isn't criminal proceedings, if the judge finds it necessary, he can compel witness by way of a summons to testify. Failure to do so would result in contempt of court, and you may be arrested and brought to the court to give evidence. Let's now explore the defenses to defamation. They are: 1. Honest opinion. We've already briefly covered this one, but to elaborate a little. This is a defense if the statement was one of opinion, indicated the basis of the opinion, whether in general or specific terms, and was an opinion which could have been held by an honest person on the basis of any fact which existed at the time the statement was made. To simplify this, if given the facts made available to you at the time, an honest person, without malicious intent, were to be able to form the same honest opinion given facts that were available to them, then this will be considered a defense. 2. Truth. If the defendant can show the statement of fact was true, then this in itself is a defense. 3. Public interest. The public interest defense is a legal defense that a publisher can use to avoid liability in a defamation claim. It allows the publisher to argue that the statement was made in the public interest and that they reasonably believed it to be true. How does the public interest defense work? The publisher must show that the statement was about a matter of public interest, or they reasonably believed the statement was in the public interest. Now that we have covered these basic legal principles, Let's relate them to the Jay Slater and other cases such as John George, and discuss Chris Tenerife's allegations about defamation. First of all, to bring about a defamatory actions, Chris, or any plaintiff, would first need to define a statement made about him that wasn't true. Then he would need to show that a statement made about him was presented as fact and not an honest opinion that others could share. This will be difficult as from the very beginning of the case, a long time before people like Duncan got involved, many people shared their opinion that they didn't believe the official accident narrative. Many people also had the opinion it was suspicious how certain individuals had made a 180-degree change in their previously held beliefs. Also in defamation, when deciding between something being a statement of fact or honest opinion is the context around it. Given that Duncan with the Jay Slater case on numerous occasions openly says we are missing vital information to know one way or another, implies that we are talking potential scenarios and honest opinions rather than facts. With regard to any legal proceedings to determine whether the alleged statement was true or false, as mentioned, witnesses may need to be called. If this is determined to be and witness summons issued, then many people involved in this case would, under oath and risk of perjury, have to give evidence in open court. In my opinion, I consider this to be a very unlikely scenario.